Welcome to today's Law of Self-Defense show. I am, of course, attorney Andrew Branca for the Law of Self-Defense. Thank you. Thank you so much. That's always so greatly appreciated. Well, today we're here to talk about whether or not the NRA, the National Rifle Association, is a reliable source for self-defense law. And I would suggest it's not. And I say that as someone who's a lifetime benefactor level member of the NRA, have been for decades. And for decades, I've also been an NRA certified instructor in rifle, pistol, personal protection. I think the organization does a lot of good. Perhaps not as much good as it could do, in one man's opinion. But nevertheless, if the question is, are they a reliable source for use of force law expertise? I would suggest they're not. And we're going to be focusing today on a column that was recently published in one of the NRA's many publications. This one is Shooting Illustrated by Sheriff Jim Wilson, who does a pretty good job in this article, but not to the standard you would want to rely on if you were looking at the possibility of a lifetime in a prison cell over an act of self-defense. So with that out of the way, let me jump into today's show. And of course, we also have the sponsor of today's content, which is none other than Law of Self-Defense, our best-selling book, Law of Self-Defense Principles, your handbook to how to be hard to convict if you're ever compelled to defend yourself, your family, your property from criminal predation. Check it out on Amazon, 5-star rated, but don't buy it on Amazon. They'll charge you for the book and the shipping and handling. I only ask that you cover the cost of shipping the book to you. We give you the book itself for free. And the holidays are here, folks. Gift giving season. Even if you already have a copy of this book, I know you have friends and loved ones who do not yet have the handbook on how to be hard to convict in self-defense. So I want to encourage you to pick up a free book for them as a gift you can give them this holiday season. You can get it for free at lawofselfdefense.com/free book. So let's dive into the substance of today's show. I know I had set aside this article. What did I do with it? From the NRA, authored by, that might have been it. Nope. Authored by Sheriff Jim Wilson. Here it is. And by the way, I think this is a pretty good article. Sheriff Jim Wilson has been writing for the NRA for probably decades, as long as I can remember, and I've been a member for decades. Does a really solid job, really good job. But I think this article reflects some common failings in communicating use of force law. And so I just want to clarify those. So this shouldn't be a critique of Sheriff Wilson. Again, I think he generally does a great job. I think he does a pretty good job on this article, but not a job that reflects genuine expertise in use of force law. So with that disclaimer out of the way, and by the way, I think the NRA, with all its resources, could be doing a vastly better job on educating its members on actual use of force law. I've offered to partner with them for years, and they seem completely disinterested. I don't know why, but that's the way it is. So the NRA, in that respect, in my opinion, could really be doing better. All right. So let's take a look at what Sheriff Wilson has to say here. And by the way, this article was recommended to me as a potential show content by none other than friend of the show, attorney Steve Gosney, a public defender, appellate division down in Florida. Great attorney, great personal friend of mine, and of law self-defense, and a professor and provost at the American Law courses, where we teach law school level courses in criminal law, criminal procedure, evidence, property, all the classic constitutional law, all the classic 1L law school courses and more, and at a law school level taught by genuine legal experts in those fields at a fraction of the cost and time commitment of law school, and without any of the leftist, progressive, diversity, equity, inclusion, woke political ideology of today's law schools. so you can get a law school level education without all that nonsense. Check it out at AmericanLawCourses.com. Thanks, Steve. So what do we have here? We have personal defense and the law. Knowledge of self-defense involves more than knowing how to draw your firearm or marksmanship. That's 100% true. Certainly agree with Sheriff Wilson there. So the first thing I notice when I read this article is one of the most common things that happens when people talk about self-defense and the law, and that is they instantly conflate, overlay on each other, weapons law and use of force law. And Sheriff Wilson is talking about personal defense and the law, and he addresses both of those, but he doesn't really distinguish between the two. And these are two completely different areas of the law. So use of force law, my area of expertise, is when can you use force in defense of yourself or others or property? And by extension, how much force can you use? Weapons law is what kind of weapons are you allowed to possess? Under what circumstances? When do you need a permit? Where can you carry? What are the limitations on carry or magazines or anything else having to do with your ability to possess and carry weapons? Now, I personally believe all weapons laws preemptively applied to mentally sound, law-abiding American citizens are all facially unconstitutional. All of them. All of them. And of course, today that would be within the Supreme Court context of the Bruin decision, which I think would invalidate virtually every gun law on the books if it was being legitimately applied by the federal courts, which sometimes it is, and unfortunately, sometimes it isn't. But that's weapons law. And I claim no particular expertise in weapons law. I know the weapons law I need to know as an American citizen who's law-abiding and mentally sound, who carries a gun for personal protection. So I don't want to violate, even though I think they're unconstitutional, I don't want to be violating those laws and creating legal jeopardy for myself. So I know the weapons law I need to know, but I don't claim any professional legal expertise in those laws, particularly not on a multi-state, 50-state level. I do claim that level of expertise in use of force law. When are you allowed to use that gun you're carrying? But not on the question of, are you allowed to carry the gun? Does that make sense? So two different things, but they're really blended here in this article. And again, that's not a particular criticism of Sheriff Wilson. Everybody does this. But when people do this, it reflects almost immediately that they've failed to think about these areas of the laws in sufficient depth to understand that these are fundamentally two different things. So Sheriff Wilson writes, not long ago, I heard about an incident I want to bring to your attention. A motorist traveling outside his state of residence was the victim of a minor traffic accident. However, during the investigation, an officer found 2 handguns in his car. The motorist was arrested for carrying without a permit, a felony in that particular state. So what are we talking about there, folks? Is that weapons law or is that use of force law? That's weapons law. Has nothing to do with the use of force. There was no use of force here. Sheriff Wilson continues, the problem was that the motorist had a concealed carry permit, all right, but only in his home state. This man was not a criminal. He had no prior arrest record. He simply was in a state that refused to recognize another state's license. What that oversight meant for this gentleman was a trip to jail, very expensive legal fees, and possibly time in prison and loss of his Second Amendment rights. And that's all true. Sheriff Wilson nails it. Now, I don't think any of that should be a consequence for an otherwise law-abiding person to have a gun in his car or on his person. But it is, folks. No one's elected me king yet. So these weapons laws, as unconstitutional as I believe them to be, are in effect. And the authorities will not hesitate to impose them on you and impose the sanctions that come with violating them. Sheriff Wilson writes, we spend a lot of time talking about guns and gear, and even some time talking about tactics. But I'm not sure we spend enough time discussing the various laws concerning personal defense. Again, he's failing to distinguish between weapons law, which he just discussed quite fairly, and use of force law. He writes, it is possible to be otherwise justified in defending oneself, yet still be charged with a crime for some violation of legal procedure. I think what he's trying to get at here, folks, is your use of force could be within the boundaries of use of force law. So your actual shooting of that person could be perfectly lawful, but you might still be violating some weapons law and be on the hook for that. The classic example of this, of course, is the Bernie Getz case from New York City back in the day, in the 1980s, I guess. I was living in New York at the time. Bernie Getz used a gun to defend himself against several armed robbers on a subway, shooting them. He was charged with use of force crimes, the state claiming the shooting was itself unlawful, and also with weapons law crimes because he had been denied a concealed carry permit by New York, and he ultimately was acquitted by jury on all the use of force charges. So his actual shooting of the robbers was perfectly lawful, but he was convicted on the weapons law charge. So that can certainly happen. And here we get to some of the conflation. So he just said, Sheriff Wilson was just talking about weapons law, but now he jumps into use of force law. For example, he writes, some states have the so-called stand your ground law. That is, if you have a legal right to be where you are, then there's no requirement to retreat before defending yourself. Nailed it. That's what stand your ground means. And that's all it means. So good for Sheriff Wilson. That, however, has nothing to do with weapons law. There's nothing about stand your ground that has to do with what kind of weapon you are allowed to be in possession with. Other states require you to attempt to retreat, sometimes with an exception when you're in your home, before responding to a violent attack. What do they consider a legitimate attempt to retreat? And this is a great question. I wish he'd had the word count to go into this in more depth. I know what it's like writing for these magazines. You have very, very strict word counts. So he probably just doesn't have the bandwidth to go into this in more detail. But if I were him, I would be writing one article about weapons law and one article about use of force law, maybe one article just on stand your ground. But certainly when the question of duty to retreat comes up, the duty only exists if you have a reasonable and practical avenue of completely safe retreat. But all of those are judgment calls that are going to be made by other people, right? What do they consider a legitimate attempt to retreat? Sheriff Wilson continues, while you may know the law in your home state, in my experience, most people don't, you are bound by the law, whatever it is, in the state that you are visiting. 100%. And trust me, he writes, they are not going to be the least bit interested in how you do it back home. They will not care a whit, folks. Your home state's laws are irrelevant if you're in a different jurisdiction. By the way, they also won't care about what you thought the laws were in the relevant jurisdiction, whether you're in your home state or visiting another state. If you are conducting yourself in self-defense or defense or another or defense of property in a way that you have been taught by a self-defense instructor or firearms instructor or gun magazine or internet website or Instagram or whatever, you're conducting yourself within the legal limits as you have been taught and as you believe them to be. But it turns out those were not the actual legal limits as reflected in actual use of force law, statutes, court decisions, jury instructions. Nobody cares what you were taught. Nobody cares that you acted in good faith. If your use of force was outside the actual legal limits as opposed to the imaginary legal limits in your head, that's all that matters. Then that was not a lawful use of force. Sheriff Wilson continues, one further example of interstate confusion. One state I know of allows a person to carry a handgun in their car if it is concealed, regardless of whether or not the person has a CCW permit. A neighboring state also allows a person to carry a handgun in their car without a permit, but only if it's in plain view. Neither state is right nor wrong. They're just different. And that difference can land a person in jail. I'm not sure. I don't know gun law well enough to know if his examples are correct. But these kinds of variances occur in many ways when it comes to weapons law from state to state. And yeah, violation of those weapons laws can easily land you in jail or even worse, in prison. So definitely, if you're carrying weapons in some jurisdiction, you owe it to yourself to make sure You know what the rules are. The actual rules are for carrying weapons in that jurisdiction. Can you carry in a bar? Can you carry in a restaurant that serves alcohol? How much alcohol as a percentage of their revenues? And blah, 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 all this nonsense that these gun control schemes come up with. Sheriff Wilson continues, gun store bull sessions have about got everyone convinced that when they use deadly force, they should just tell investigators that they were in fear for their life or serious bodily harm. But you might be aware that this is not the get out of jail free card. It is often implied. In fact, I would suggest that just telling investigators a bunch of stuff is a go to jail card. Go to jail, do not pass go, do not collect $200. For those of you who remember Monopoly, if people still play Monopoly. As I often say, we spend almost an hour talking about interacting with the police in the aftermath of a use of force event in our full day course here at Law of Self-Defense. There's a lot of subtleties there that the prudent person ought to consider. And falling back on the strategies of say nothing is not a bad choice for most people, at least for many people. I think there's a more professional approach to interacting with the police, but what it does not include, that professional approach, is simply blathering to the police some narrative of what you think happened and why it might have been lawful. You're far more likely to talk your way into prison than you are to help yourself by simply speaking to investigators in the absence of having your own legal counsel present. Wilson continues, most states, maybe all of them, apply the test of reasonableness to the situation. Well, it's interesting he says that because, again, we have a conflation here of use of force law and weapons law. So reasonableness is one of the elements of a claim of self-defense. So most of use of force law, a reasonableness standard is applied. You could be mistaken, but that's okay. Mistakes are allowed in self-defense. We're not required to make perfect decisions in self-defense. We're only required to make reasonable decisions in self-defense, meaning use of force law. Weapons laws tend not to rely on reasonableness. Many of them are simply possession laws. Unless you can say that unbeknownst to you, someone put that pistol in your backpack. If you're in possession, you're in possession. And if it's illegal for you to be in possession, you violated that statute and there's no reasonableness about it. So reasonableness does not tend to apply to weapons law, but it does tend to apply to use of force law. And another reason why conflating them can be dangerous. Wilson continues, were the actions of the attacker such that the use of deadly force was reasonable and necessary? Was the response of the victim reasonable under those circumstances? And then one might still be in trouble because he forgot to retreat first. Fair enough. That's all use of force law, right? None of that is weapons law. He continues, clearly it is critically important for the armed citizen to know and understand the laws about carrying firearms. Well, now we're back to weapons law and the use of deadly force. And now we're back into use of force law. One needs to not only understand the law, but one should also understand how it is applied based upon court rulings. That's definitely true. So I often caution people that many of you have looked at the statutes on use of force law in your jurisdiction. So you went to get your concealed carry permit. You took a mandatory course. At some point in that course, they got to the legal portion, and the instructor of the course read you a bunch of statutory language, read you a bunch of statutes. And that's great. You should know the statutes in your state. But statutes don't always mean what the apparent plain English reading of the statute would appear to mean. Statutes by themselves don't have any effect in the real world. They're just words on paper. Statutes don't have effect in the real world until they are interpreted and applied by courts to real people in real court cases. And then that's evaluated by the appellate courts and their interpretation and application of the statutory language. And it's not unusual for the courts to interpret and apply statutes in a manner that would seem inconsistent with the plain English reading of the statute. So statutes don't mean what the legislature intended them to mean when they pass them into law. They mean what the courts that are interpreting and applying the statutes say they mean. Wilson writes, again, what is a reasonable attempt to retreat? What one really wants to avoid is getting their lessons in the law from the guys down at the local gun shop, or even from an old sheriff turned gun writer. Here, Wilson's being self-deprecating about himself, right? Sheriff Jim Wilson. And that's absolutely true. Don't assume simply because someone has a particular job title that they know anything about self-defense law. That includes lawyers. Most lawyers don't know anything about use of force law. In my 3 years in law school, we spent maybe 5, maybe 10 minutes talking about use of force law in first year criminal law, which, by the way, you can learn first year criminal law at AmericanLawCourses.com at a fraction of the cost and time commitment and without any of the politics, toxic politics of today's law schools. Learn more at AmericanLawCourses.com. Just because someone has a job title, most attorneys don't know use of force law. They weren't taught it. They have no professional need to know it. If they're not criminal defense attorneys, they definitely have no professional need to know use of force law. Most cops don't really know use of force law. They were taught at the academy just enough to try to protect their department from civil liability, not to protect themselves from criminal liability. Most self-defense instructors don't know much about. They've just, and it's not because there's anything wrong with self-defense instructors. I'm a self-defense instructor myself. It's because most instructors were not provided with a very good opportunity to be taught proper use of force law. By the way, here at Law Self-Defense, we also have a self-defense law program for instructors. That's the equivalent of a law school level semester-long course on use of force law. Those people who graduate from that program, and you have to pass a very rigorous examination to be certified. But those people who hold that certification, those instructors, they really know self-defense law. But it's because they made the personal effort to learn the actual law of self-defense. You can learn more about the Law of Self-Defense Instructor Program if that's of interest at lawofselfdefense.com/instructor. So just because someone's a lawyer or a cop or a self-defense instructor or firearms instructor or works at or hangs out at the local gun store, do not assume they know anything correct about use of force law. In fact, much of what they know is probably wrong. Wilson encourages, instead, you go to the source and invite someone from your local DA's office to come to your gun club meetings and explain the law and how it is interpreted. Again, most lawyers don't really know use of force law. In my experience, most prosecutors don't really know use of force law. Most criminal defense lawyers don't really know use of force law at anything like the level. Now, your local DA might, and he might at least know his limitations in knowledge. So that would be helpful. But don't make the assumption, by the way, that whatever your DA tells you in some kind of instructional forum is binding on the DA. If you do what he says would be okay in the classroom and he decides to prosecute you anyway, he's allowed to do that. Failing that, have a local attorney versed in the Second Amendment talk to your group. Again, we're really failing to distinguish here between use of force law and gun law. The Second Amendment doesn't talk about use of force law. It doesn't tell you when you can use those arms that you're allowed to keep and bear without infringement. It just says you're allowed to keep and bear them without infringement. The Second Amendment is a weapons law. It's not a use of force law. He writes, when traveling with firearms, it's a good idea to research the gun laws in the states you will be visiting and those that you will be traveling through. Good advice. Most of these laws can be found on the internet. Visit the NRA ILA website first. And even though you may not get a full understanding, you will at least have a general idea. Also, some items that are perfectly legal in your state may be prohibited in others, and that includes magazines and ammo. And of course, I should mention, you should know this if you own these things, but any NFA items, National Firearms Act items, fully automatic weapons, suppressors, things like that, there the limit is federal. Well, it could also be state. So some states have an outright prohibition, for example, on a small minority. I think it's about 10 states have a state level prohibition on suppressors, for example. I believe New York State is one of those. Massachusetts might be one of those too. I'm not sure. So if you may have a suppressor in your home state, perfectly legal. You're bringing it to New York, it's a felony. Fully automatic weapons, illegal in New York. Even though the feds would allow it, New York State says no. Legal in Massachusetts to own fully automatic firearms, as long as you pass the federal requirements. And as I understand it, the feds require if you're perfectly lawful in possession of a restricted item like fully automatic or suppressors in your home state, before you can take them to another state, you have to notify them and get their permission. So all that is definitely true. Sheriff Wilson says, if you are beginning to feel confused, you are on the right track. Yet you are required to abide by the law in whatever jurisdiction you might be. I didn't know the law, or I didn't understand the law, is probably not going to be considered a good defense. Yeah, it's zero defense. Even though you may feel that you are right and may be right from a constitutional perspective, I would concur with Sheriff Wilson there. You can be faced with a trip to jail, confiscation of your property, and the expense of tens of thousands of dollars. And that is if you beat the charge. If you don't, you get prison time on top of all that other stuff. Fair enough. Nailed it. Educate yourself, he writes. Get good legal advice, folks. Good legal advice. And understand that this is way better than thinking you can talk your way out of the problem. And this touches on the whole, I'd rather be judged by 12 than carried by 6 crowd. And that's why I'm not going to learn the actual law of self-defense. And as applied to weapons law too, folks, that's a non-thinking approach to the incredible legal liability you're looking at. Do the work and know this stuff. Don't be willfully ignorant. That only puts you at risk. Knowing and understanding the law is just as important as knowing how to defend yourself. I would say it's pretty close. As I always caution folks, I just teach the legal stuff, right? But winning the fight's got to be the first priority. If you don't win the physical fight, everything else becomes less pressing. So you have to make winning the fight the first priority. If you lose the physical fight, the other stuff, the legal stuff, doesn't really matter. But you don't want to win the physical fight in such a way that you just end up spending the rest of your life in a cage with really unpleasant people. You want to win the physical fight in such a way that you also avoid the legal liability because your use of force was lawful, simply was not a crime. That's where you want to be. That's why we teach the legal stuff. Now, first you have to live. But once you've lived, once you've won the physical fight, you also want to make sure that your use of force was within the legal boundaries. And it's possible to do that, is the good news, is both win the fight and do it in a lawful way that makes you hard to convict. All right, folks, I think that's all I wanted to share from that. I forgot to take down the little instructor banner. Remember, giving season is here, folks. You can get your copy of The Law of Self-Defense Principles, our best-selling book, at lawofselfdefense.com/free book. lawofselfdefense.com/free book. 5-star rated on Amazon, but don't buy it there. They'll charge you for the book. We'll give you the book for free. We just ask you to cover the cost of shipping it to you. Get that at lawofselfdefense.com/free book. And with that out of the way, I will thank you all for being here again. And until next time, remember, if you carry a gun, so you're hard to kill. If you carry a knife, so you're hard to kill. If you carry pepper spray, so you're hard to kill. If you study jujitsu or some other martial art, so you're hard to kill, so your family is hard to kill. That's why I do all those things. So me and my family can be hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.